Imagine a judge admitting that the future of tech is just too fast, too unpredictable, even for the highest courts in the land. What if the most anticipated tech battle of our time wasn't won or lost in a courtroom, but in the relentless pace of innovation itself? For years now, we've watched a high-stakes legal drama unfold, the U.S. government taking on one of the biggest names in tech, Google. The core argument? That Google's dominance in search and advertising stifled competition. And just recently, in a decision from the U.S. District Court for the District of Columbia, we saw the outcome of a major chapter in this saga. Now, you might have expected a seismic shift, perhaps a breakup of the tech giant. The government certainly asked for a lot. They pushed for Google to sell off its incredibly popular Chrome browser and demanded it share vast amounts of its most valuable search data. Those were big asks, essentially asking for a complete restructuring of a core part of Google's empire. But the ruling we got was far more measured. The court decided to take a cautious approach, signaling a real reluctance to dive too deeply into these fast-moving, high-tech markets. The judge did put some new rules in place for Google. They will need to share some search data with competitors, and they'll face restrictions on the big payments they use to ensure Google Search gets prime placement in our web browsers and on our smartphones. Think of it like a referee telling a dominant player they can't always have the ball handed to them directly. It's a significant tweak, but certainly not the dramatic overhaul the government was hoping for. William Kovacic, a law professor and former chairman of the Federal Trade Commission, really hit the nail on the head when he called this a cautious ruling. He explained that the judge just wasn't convinced that the more drastic sanctions the government proposed were truly warranted or even appropriate in this rapidly changing landscape. And this brings us to perhaps the most fascinating part of the judge's reasoning. Judge Mehta pointed directly to the rapid, almost dizzying advances in artificial intelligence. AI, he argued, is already fundamentally shaking up how all of us search for information. He highlighted the unique challenge this presents. In most antitrust cases, a court looks backward, resolving disputes based on past facts. But here, he observed, the court is asked to gaze into a crystal ball and look to the future. And he admitted, with a touch of understatement, not exactly a judge's forte. It's like asking someone to predict the exact path of a hurricane that's still forming over the ocean. The landscape simply shifts too quickly for traditional legal frameworks to keep up. So, this ruling leaves us with a compelling question. As AI continues to reshape the very foundations of how we find and interact with information, can our legal systems truly keep pace? Or are courts destined to always be a few steps behind, trying to regulate a future that's already here? We'd love to hear your thoughts on this. Does this ruling protect competition, or is it a missed opportunity? Share your insights with us, and we'll catch you next time as we dive deeper into the ever-evolving world of tech.